Hi everyone, welcome from Law with Dunk the Law Guy, and today I'll be Dunk Pool for day 54 of the Case of Day series journey, covering cases across criminal law, tort law, contract law and the English legal system. If you ever have a case you want me to cover, pop it in the comments section and I'll get round to it. Continuing today with more cases relevant to the criminal offence of assault, I'd like to cover the famous case of R.V. Ireland 1997 and explore how an offence was present in this case. Just to reiterate, we know that an assault is defined as an act, requirement 1, that causes the victim to apprehend, requirement 2, immediate, requirement 3, unlawful, requirement 4, violence. And that's the actus reus of an assault. So if I go back through that, for the actus reus of an assault, it requires an act from the defendant. It can't be an omission, which is a failure to act. It must be a positive voluntary act, so an act that then goes on to cause the victim to apprehend immediate unlawful violence. So that's cool. And the mens rea of an assault is either intention or recklessness to cause the victim to apprehend immediate unlawful violence. Now, just so you're aware, when I teach my students, I always stress direct intent, as of R.V. Mohan, which is, was it the defendant's main aim, desire or purpose to cause a particular result, and I just condense that down to main aim. Or recklessness, subjective recklessness, R.V. Cunningham, did the defendant appreciate the risk of, an outcome happening and go on to take the risk. So you've got to ask yourself, basically, when you're explaining and applying the mens rea of an assault, is there a direct intent to cause the victim to apprehend immediate unlawful violence, i.e. is it the defendant's main aim? Or if it's not their main aim, was the defendant reckless in causing the victim to apprehend immediate unlawful violence? Did the defendant appreciate the risk of the victim apprehending immediate unlawful violence and go on to take that risk? I stay well away from indirect intent. I just go with direct intent or recklessness. Simply because I only use indirect intent for the most serious crimes, such as like Section 18 of the Offences Against the Person Act 1861 or murder, basically where recklessness isn't an option. I always tell my students to pick from either a direct intent or an indirect intent. Technically, I think you can use indirect intent for attempted murder as well. Anyway, moving on from that, we know that an act for the purposes of an assault could be written words contained within a letter or series of letters sent to the victim, as seen in R.V. Constanza 1997. Please see the Day 51 Part B recording for that case. Spitting, as seen in R.V. Mizzolatti 2017. Again, I hope I've pronounced that case right, but please see the Day 52 recording for R.V. Mizzolatti. And throwing a punch, as seen in R.V. Nelson 2013. Please see the Day 53 recording there. In R.V. Ireland 1997, the defendant had many silent telephone calls to 3 women over 3 months. Sadly, all 3 women went on to suffer psychiatric illness from this. The defendant was therefore found guilty at trial of multiple offences under Section 47 of the Offences Against the Person Act 1861. Here, his multiple assaults had caused multiple psychiatric ABH, or actual bodily harm injuries, to be sustained by his victims. At trial, it was necessary to prove an assault for the first part of Step 1 of each of these Section 47 ABH offences. I'm just going to say, lawyers, when they talk to one another, they won't, if they're in an elevator and they're talking about their clients and whether they've been charged with so on, or whether they're a prosecution lawyer and they're charging so-and-so with a particular offence, they won't say, oh, I charge this individual with a Section 47 of the Offences Against the Person Act 1861 or a Section 47 offence under the Offences Against the Person Act 1861, because it's such a mouthful. So instead they just say ABH. So that's why, if I ever say the ABH offence, I mean Section 47 of the Offences Against the Person Act 1861. I would, though, for my students, always say charge an offender, or a defendant, I should say, charge the defendant with a Section 47 offence under the Offences Against the Person Act 1861. I say that because Step 3, or the final part of the actus reus of that criminal offence, is to prove whether the victim sustained ABH. physical ABH or psychiatric ABH. So the point I'm saying before I move on, the point I'm trying to make before I move on from this is it can be a little bit confusing if you say Section 47 ABH, but you don't actually explain the full offence. And also, when you actually go through the 4 steps of this offence, step 1, actus reus of assault or battery, or the actus reus of common assault, which collectively means the actus reus of assault or battery. Step 2, occasioning, which just means the rules of causation as of R.V. Roberts. So that's step 2 of the actus reus. Step 3 of the actus reus, the final part of the actus reus, is there actual bodily harm? ABH, physical or psychiatric, so my voice is going. It goes high every now and again, that's why I was smiling earlier. Anyway, and then the final part is the mens rea of common assault, or the mens rea of assault or battery, as of R.V. Savage, R.V. Roberts. That is enough for the mens rea of Section 47 offence. So, ABH being the third requirement, or actual bodily harm, just keep that there. If you need to explain this offence and you're doing an exam paper, never ever call it just ABH, the charge. Always call it Section 47 of the Offences Against the Person Act 1861. Anyway, that's just been stressed regarding at trial R.V. Ireland. So moving forward, after being found guilty at trial of these offences, Ireland eventually appealed to the House of Lords on a number of grounds, first arguing that silence itself could not amount to an act for the purposes of an assault, and secondly arguing that psychiatric injury did not fall within the definition of bodily harm. Multiple legal points have therefore been considered here. On appeal, there's not just one legal principle from this case. Ireland's lawyers are taking issue with 2 things in particular. That's why there's quite a few things to take away from this case. The first thing being, Ireland's arguing, well, silence can't be an act for the purposes of an assault, so he's taking issue with a breakdown of step 1 of the criminal offence here, saying there's no actus reus of an assault. He's also taking issue with step 3 of this criminal offence, saying there's no ABH, saying the psychiatric injury here didn't fall within the definition of actual bodily harm. So multiple legal points to consider here. So you can see that this case is very much an assault case, but it crosses over with Section 47 as well. The House of Lords upheld Ireland's trial convictions, deciding that silence can amount to an act for the purposes of an assault, and also stated that psychiatric injury could fall within the definition of bodily harm. With the first appeal point of consideration, the House of Lords stressed that a victim of silent telephone calls may fear or apprehend that the caller was about to arrive at the victim's home. Again, I hate that word fear. Try and just stick to apprehend or expect. As a result, the victim could fear or apprehend the possibility of immediate personal violence. I only say that because fear's a bit narrow. Apprehend's a lot wider. Anyway, this case also helps provide clarification on the meaning of immediate, and for it to not mean that the victim must apprehend instantaneous violence, as violence would therefore have to most likely be performed instantly after the defendant's act of making the silent telephone calls. Instead, the word immediate was deemed to mean violence to be expected or apprehended imminently, i.e. in the near future, as was the case here, regardless of where the defendant was located in the world when making the phone calls. Here, the victims could each fear or expect the caller to arrive at their homes, and thus could still apprehend/expect the possibility of immediate, i.e. imminent, personal violence. Immediacy or immediate therefore means where the victim expects force or violence about to happen in the near future. Before I wrap this up, I'll just say, so there's 3 things we can take away from that. Silence can be an act for the purposes of an assault, so silent telephone calls. Psychiatric injury can fall within, actual bodily harm for the purposes of a Section 47 offence of the Offences Against the Person Act 1861. And R.V. Ireland also has another legal point, or another part of the ratio decidendi, binding precedent aspect of the judgment, in that immediate, so the actus reus of an assault is an act that causes the victim to apprehend immediate unlawful violence. What do we mean by immediate? Well, it doesn't mean instantaneous violence to be expected by the victim. It means potentially imminent or about to happen, maybe in the near future, potentially, violence to be expected by the victim. I always use this example. If I had a student who was late for class and I rang them up and I said, "Where are you?" and they said, I will be arriving instantaneously. I would expect them to walk through the door as I'm on the phone to them. But if they said I'm arriving imminently, I would therefore think, okay, they're nearby. Okay, so hopefully that helps your understanding there. Anyway, that's it for today. Thank you from Law with Dunk, the law guy, and I'll hopefully see you tomorrow.